Yes, Senator.
We're live.
All right.
I'll just hold on to the question for them.
Okay. Our first witness on S71, James Levy of St. Albans, I believe.
Correct,
Mr. Levy,
correct, sir.
feel free to let us know what you'd like to tell us about the bill.
Okay, well, I'm here today on my own volition. I am not representing any particular interests. I should point out by way of my background that I have considerable experience in the area of hospital debt collection. Indeed, for the last 30 years, my law office has represented 9 or 10 of Vermont's 14 nonprofit community-based hospitals. I emphasize the words nonprofit community-based hospitals. I think that's very important in considering whether or not there should be modifications to the Vermont hospital lien statute. My background, though my professional background is primarily in the general practice of law. Ironically, in the context of this present discussion, for many years, one of the specialties of my general practice was representing injured parties in claims against third parties, tortfeasors. So I have some experience in personal injury law, and in a sense, I have some perspective that might be of interest to the committee. I'm very familiar with Vermont's hospital lien law. In the context of my hospital debt collection practice, the hospital lien statute has been of a measurable assistance in facilitating the satisfaction of hospital debts. I'd like to read to you just briefly a mission statement of how my law office approaches hospital debt collection. This is from a hospital debt collection practice overview of my practice. And I think it's important that the committee realize that hospital debt collection practice can be and should be conducted in an ethical, elegant fashion. So I'll quote now: all of our collection initiatives are pursued with sensitivity to the public relation problems experienced by healthcare providers generally, and we are cognizant of the dynamics in play nationally and in Vermont, particularly on this subject. Succinctly put, in the present political climate, and by the way, that was, I think, in 2008, succinctly put, in the present political climate, collection of hospital accounts occurs in a glass bowl, metaphorically speaking, and it is our professional obligation to minimize the negative image endemic to this practice area and to protect the integrity of our hospital clients. Essentially, I would always be very distraught and upset if a patient, and it's important to emphasize the word patient, this is not a defendant or an individual who should be treated with anything but the utmost respect. I'd be very upset if through any activities conducted through my office, a hospital was subjected to criticism or a sense that there was no sensitivity to the needs of the patient. Now, with that as a background, I'd like to discuss exactly what S79 may mean in the context of my activities and others. I think there are 3 elements to the bill which are very of great concern to myself, and I think I'll start with the provision having to do with requiring the submission of a hospital bill to a health insurer when a health insurer exists. The committee should be aware that to the extent that Medicaid or Medicare is available, there are federal and state regulations and laws, which I do believe preclude that submission to Medicaid or Medicare. I know that in the original formations of, or in the original formulation of the Medicaid Providers Manual and also the Medicare Providers Manual, there is language, which I'll quote now from the Medicare Providers Manual at Chapter 3. It's stated in the original version, quote, "The law mandates that Medicare is secondary payer for claims involving automobile or non-automobile liability or no fault." It's consistent with this, the Medicaid Providers Manual, I think it was a section 1.2.8, I might be wrong on the citation, states that, quote, "When the EDS system shows a source other than the OVHA is primary payer, such as Medicare or any other insurance carrier, the OVHA is the payer of last resort." That's something to consider, payer of last resort. End of quotes. And finally, in the Center for Medicaid and State Operations fact sheet, there's a quotation, quote, "According to federal law, the Medicaid program is intended to be the payer of last resort. That is, Medicaid pays only after other third-party sources have met their legal obligation to pay." End of quote. And there's good reason for this. Why? I think if the hospital bill is submitted to a private health insurer, say Blue Cross Blue Shield, let's take a hypothetical bill. And I think if you look at one of the submissions I have made, I call it Torts 101, what you need to know about S79, but may not have asked. If you look at the dollar amounts, a $50,000 hospital bill, if it were submitted to Blue Cross Blue Shield, maybe 70% of that amount will be paid. But most disturbingly, moving down the food chain, if the same bill were Medicaid, it could very well result in a $10,000 payment to the hospital. Why is this important? Because to the extent that hospitals are unable to obtain satisfaction of a $50,000 bill, for example, to that extent, there's a revenue shortfall. And eventually that revenue shortfall will have to be made good. How will that be accomplished? It can be done in several forms, or actually it will morph out in many different forms. One will be self-insured patients. That means patients who do not have any type of insurance. Maybe the following fiscal year will see that $50,000 bill be $75,000. Similarly, Blue Cross Blue Shield, if it pays the bill, the hospitals will be raising their rates to Blue Cross Blue Shield and other health insurers. And that rate increase charged to the health insurer will eventually result in higher premiums charged to subscribers of the health insurance. And to the extent that self-insured patients and health insurers don't pick up the shortfall, governmental bodies might be required to pay some type of supplement to the hospitals, and ultimately taxpayers absorb the cost. I think there is a question of the legality, as I've mentioned, in terms of requiring the submission to Medicaid or Medicare before exhausting third-party resources. The second problem with S79 is the adoption of what essentially is the common fund doctrine in Vermont in the context of hospital bills. Essentially, the provision of S79, which states that a hospital that recovers under this chapter shall be responsible for a pro rata share of the legal and administrative expenses incurred in obtaining the judgment, settlement, or compromise. that adopts the common fund doctrine in Vermont to hospital liens. And that goes against case law in Vermont. In one of my submissions, I've cited the relevant cases which have addressed this issue. The most succinct holding directly in point is not a Vermont Supreme Court case, but actually is a Superior Court decision of Judge Helen Tour, which unequivocally rejected the notion that the common fund doctrine, the pro rata sharing of costs, be adopted in the context of hospital liens. I think it's a very dangerous, slippery slope that would be pursued, and it should be definitely should not occur in Vermont. I find it somewhat disingenuous that before I get to that, the most obnoxious or most offensive provision of S79, though, is the very last part. And that would be the provision that in no event shall the hospital lien exceed 25% of the net judgment, settlement, or compromise received by the injured patient. I think at this point, we should look at towards 101. And I think it's very, very important. And I tried as best I could to give a hypothetical factual situation where there was a $50,000 hospital bill incurred. The total settlement was $150,000 in the tort settlement derived in the third-party claim asserted against the insurance carrier. And if you look at there are three scenarios that play out, and I think it's important that we consider all three scenarios. The first scenario is under the existing hospital lien statute, where you have the $50,000 bill reduced by $500, and the hospital, we call it Mercy Hospital in this example, receives a payment of $49,500. By the way, in all three scenarios, the legal fees due the patient plaintiff's attorneys is the same. It's $50,000. 1/3 is the standard provision contingent fee, usually charged by a law firm representing an injured patient. So in all three of the scenarios I've shown, the legal fees due the patient's attorney would be the same, absent negotiation between the patient and the attorney. So in the first example, under the existing hospital lien statute, the hospital would receive $49,500. The patient, Mr. Smith, would receive a $50,500 net. The second scenario involves a situation where there is no health insurance, because if there were health insurance, the third scenario kicks in. But assuming there is no health insurance available to Mr. Smith and a $50,000 hospital bill exists, a hospital lien has been filed. First, and $150,000 total settlement is achieved. In that scenario, if S79 unaltered becomes law, the legal fees due Able Law Firm would be $50,000. That doesn't change. But what changes dramatically is the amount that Mercy Hospital's $50,000 bill has been reduced by. Instead of $50,000, it becomes, by my calculations, and keep in mind I was a history major, not a math major, but it seems to me that if we put a cap, as S79 contemplates, at 25% of the net judgment, settlement, or compromise received by the injured patient, if you take the $50,000 legal fees due Able Law, that leaves $100,000 net due the patient, from which the hospital lien could not exceed 25% of $100,000 $50,000. So by my rudimentary mathematical calculations, that's 25,000. So right from the get-go, the $50,000 is 25,000. And if we apply the common fund doctrine or the pro rata share of legal fees, most plaintiffs' attorneys would say that the pro rata share would be 1/3 of the 25,000, meaning $8,333. So we knock another $8,333 from the already discounted hospital bill down to 25,000, and it becomes $16,667. That's a huge discount. And now, again, eventually, if these type of provisions are adopted, there will be significant diminutions of revenues to the hospitals. I have to say that this line of logic has led me to a whole new view of the, or actually has given me a new definition to the term chutzpah. Chutzpah in this instance would be the trial attorneys, able law, using effectively, as always trial attorneys would, the existence of significant medical expense, $50,000 of medical bills, convincing Acme Insurance that Smith incurred serious injuries, thereby justifying a $150,000 settlement. Chutzpah in this instance means using these hospital bills to jack up a total settlement, and then having the temerity to deny payment of these very same bills, which resulted in the handsome settlement, denying payment to the hospitals that were in part responsible for the realization of a very favorable settlement. I think this is outrageous, and it certainly is not equitable. I do believe that we have oversimplified in many senses how the hospital behaves in the context of interacting with plaintiffs or trial lawyers in the resolution of claims. There are many different scenarios, but I'd like to address a few of them because I think it gives a understanding of the dynamic of the playing field. There are numerous instances where the hospital lien statute has served in a very beneficial way the injured patient. I'll give you just a couple of examples. We actually had a case about, I'm going to say 10 or 15 years ago, where an elderly lady who obviously did not have a great deal of financial wherewithal contacted our office almost in tears saying, I have a $25,000 hospital bill from one of your hospital clients. There's no way I can afford to pay it. And in talking to her, it turned out that the hospital bill was attributable to an accident which she incurred in slipping and falling in I think it was a drugstore, and that she was injured by virtue of this, what we would, a plaintiff's attorney would call a slip fall case. In talking with her, I said, have you considered pursuing a third-party claim against that drugstore? And she said, what is that? And I explained what it was. She said, can you represent me in this matter? I said, absolutely not. I represent the hospital. There would be a conflict of interest. I referred the matter to an attorney actually in Brattleboro, Lauren Crisp, a true gentleman and an expert in this area. At the end of the day, that $25,000 hospital bill morphed into a settlement much more than that. The injured patient gleefully paid the $25,000 and pocketed a significant amount as well. That was an example where the tort system served to the betterment of the injured patient, and it resulted in a full payment to the hospital And I think the attorney involved, Mr. Chris, benefited as well. There are other scenarios as well. I think there had been mention made, I think, by Attorney Ross, where there is insufficient funds available in a settlement. I just resolved a case with a Houston, Texas attorney earlier this week where there was a $30,000 settlement. My client's hospital bill was over $17,428. His legal fees would be 1/3, $10,000. If we insisted on the satisfaction of this $17,428, or actually take $500 off it, it still would have left virtually nothing for his injured client. We negotiated an arrangement, and this is something my hospital clients uniformly do, where there are insufficient funds. There's always a way to resolve it. The Houston attorney agreed to reduce his own fees. Instead of taking 130, said, I'll cut my fees by 20%. I said, the hospital certainly will match that, and we did. We had a final resolution where the $30,000 was split. Instead of the hospital getting $17,500, it ended up with a $14,000 payment. The attorney graciously agreed to take $8,000 instead of $10,000, and the patient realized a payment of $8,000. Another aspect of this whole playing field is the hospital takes tremendous risk in making a determination. Does it assert a hospital lien, or should it bill the health insurer? This would be in a situation where health insurance exists. Sometimes it would be more prudent for the hospital to back off and not pursue a third-party claim. I had an instance several years ago where a patient had fallen off a platform in an Amtrak station, severely injuring himself. I had discussions with his attorney, who indicated it's a very difficult case from a liability perspective to pursue. Do you really want to assert a hospital lien? We thought about it. I looked at the accident report, and I advised my client not to assert a hospital lien. Why? Because, among other things, the window of opportunity for obtaining payment on a health insurance matter usually is about 1 year. A claim such as that Amtrak claim would take well over a year. And does the hospital really want to gamble and put all of its eggs in one basket? What happens if at the end of the process there is $0? The plaintiff's attorney is unable to obtain any money. The hospital similarly would derive nothing. So that was an instance where the hospital determined correctly, in my view, not to assert a claim and it's against a third-party carrier, but to file a claim with a private health insurer. If this were a Medicare
Mr. Levy,
or a Medicaid,
Mr. Levy,
yeah.
we've been going for 25 minutes. I wonder if you could wind down and give the committee
Yes,
a chance to answer questions if they have any.
Yes, I'll just make one other example and then I will close. There was mention made about how the patient should have choice. Under the existing scenario, I'm aware of at least one case recently where I was a plaintiff's counsel with another attorney, and we wanted the hospital to assert a hospital lien. And there are instances where hospital liens are beneficial to the patient. In this instance, the patient had a health insurance policy with a $5,000 deductible and did not want his health insurer billed. Why? Because he would be taking the first $5,000 crack. He wanted the hospital to assert a lien because it would serve his interests. I will close simply by, I'd like to read into the record a letter from the CFO of one of my hospital clients. I have his permission to do this. His name is David Sandville. He's the CFO of Mount Scottney Hospital. And he says as follows, and I'm quoting from his letter. He says, aside from the cost shift and the resulting increase of uncompensated costs passed on to consumers, employers, and taxpayers, it seems rather unconscionable for the attorney to receive full compensation for their contingency rate of 33% plus out-of-pockets when the hospital, who likely saved, treated, improved the patient's quality of life, gets hammered financially. It's hard to imagine a world where the attorney's effort is more valuable than the hospital's efforts. It's important to note that the hospital provided the necessary care regardless of the patient's health insurance coverage, nor their ability to pay without question. The hospital often waits literally years for resolution, fronting all of the costs of care in the hopes of being compensated for their good work at some point. A state full of not-for-profit hospitals cannot continue to be the indirect source of relief for all of the ills of our legal and healthcare systems. As a matter of practice, the cases where there is not enough to go around for all parties involved, we typically propose similar discounted reimbursement for all parties involved, i.e. the patient, the patient's legal representation, hospitals, etc. And that's the words which I think best summarizes the very difficult situation Vermont's 14 nonprofit community-based hospitals find themselves in. Thank you very much.
Thank you. Are there any questions for Mr. Levy from the committee?
Senator Bohofsky has a question.
Yeah, I'm just wanting to make sure my understanding is correct that your law firm has a direct fiduciary interest in maintaining the current statute.
Fiduciary interest, I'm not sure I understand. A fiduciary interest would
A financial interest.
I don't, I certainly have derived funds for my hospital clients and I do bill them for my services. Do I have an interest in it? It's a tool of the process. So certainly it makes easier the fruition of the maximum amounts of monies due my hospital clients. That's correct.
Okay, thank you.
Thank you. Any other questions for Mr. Levy? Thank you very much. Our next witness is Sarah Teachout from Blue Cross Blue Shield.
Thank you.
Morning, Sarah.
Hello. Sarah Teachout with Blue Cross and Blue Shield of Vermont. I'm the Director of Government Relations. Just a quick, I think you all know, but Blue Cross and Blue Shield of Vermont is a single state blue plan. There's 34 Blue Cross and Blue Shield plans across the country. We are only serve Vermont and Vermont residents. We're the second smallest blue plan in the country, and about 1 in 3 Vermonters have Blue Cross and Blue Shield of Vermont coverage. We cover Vermonters in every marketplace, the Affordable Care Act marketplace, the large group marketplace, self-insured marketplace, and all of the Medicare products. So Medicare Supplement, Medicare Advantage, and federal employees as well. So pretty broad coverage. We strongly support the intent of this bill to limit and in some instances prohibit hospital liens against damages recovered by a patient after a serious accident. This is an important consumer protection, and the statute should be updated to prevent the exploitation of individuals and families by our tangled financial web of the healthcare system. Unfortunately, massive medical bills are all too common as the prices for hospital services have risen dramatically in recent years. I would say that I misread the current law when I wrote the email to you all last week, so I just want to say that up front. Allowing the hospital claims to take all except for $500 of the financial settlement, I had it completely backwards. So I want to get that on the record that I was wrong. This legislation would expand safeguards for both insured and uninsured Vermonters. For Blue Cross, protecting our members against financial catastrophe of medical bills is our top priority. So the proposed legislation would require a hospital to accept a patient's health insurance coverage as payment, allowing nonprofit hospitals to seek payment through liens against Vermonters with health insurance, Medicaid, Medicare, or commercial insurance undermines the value of the coverage and the financial protection that enrollment in health insurance provides. People rightly expect that after investing in monthly premiums, their health insurance plan will be accepted by providers to cover medical expenses. This change would guarantee that protection. And speaking about 1B in the legislation, I do have a request, however. I request that you eliminate the last clause in that, the requirement that the hospital and the insurer have a contract. So that's on page 2. Section 1, and it's lines 17 and 18, starting with the comma and then the and the hospital has a contractual agreement with the payer. So what this does is it says that this would only apply for an in-network bill. Congress, I think it was 2 years ago now, passed the No Surprises Act that deals with out-of-network issues. So the insurer and the provider, there's a whole process, arbitration for how to deal with a bill for an out-of-network provider. And I think this would be also a little bit difficult to implement. As you know, carriers can and providers can terminate a contract and the patient may know nothing about it. So that's my one request here. I also did want to talk about an important protection of having health insurance is that we negotiate the rates. So that's a really big piece of this, is that the patient is protected because they're getting a negotiated rate. We're reviewing the claims and the coding and making sure that it's all accurate. So that, and so by allowing a hospital lien to go over the insurance, you're allowing the hospital to charge an unnegotiated rate, which we think is a significant protection of having health insurance. I did send around an article, and I think you've all seen it, about hospitals that choose to forego, say, Medicaid rates and try and seek these liens. The person is unprotected against the total cost of the bill. It circumvents the purpose of health insurance and the rates negotiated by the payers in favor of larger payouts from automotive claims. It adds unnecessary financial risk for patients. So in the instance of an uninsured individual, and I'm not representing uninsured individuals, but they're certainly an important part. There's about a 3% uninsured rate here in Vermont. This pits personal insolvency against hospital bad debt. Hospital liens used in this manner violate the faith Vermonters have in our nonprofit hospital system and the generous financial benefits each of these medical institutions enjoy in exchange for contributing to the common good in their communities. So we strongly encourage you to pass this bill with the one change that I recommended. I'm happy to answer questions.
Are there questions for Sarah? Thank you very much, Sarah. Appreciate
Be
it.
very clear. Thank you.
Committee, do we have some discussion here? I unfortunately missed the first round of testimony on the bill. So.
I have a question, Senator Sears. I need
Yep.
some clarification from Ledge Council. Everything that I've heard, if we have several co-sponsors here, from what I can gather, we've got the insurance companies, aka Blue Cross Blue Shield, we've got the hospitals, we have got the victims, shall we say, and attorneys. Somebody just needs to explain to me this bill. It's like I can get into context as to, they all seem to have concerns here, but I have to put it like this: who's right, who's wrong? What is going on with this, Avery? Let me tell you what's going on with this. This is a very confusing bill. It's just,
yeah, maybe if Ledge Council could take I can't tell if she's here in the building or.
She's here.
Oh, good.
For the record, Amber and Aberdaily Legislative Council. I believe what you are looking at here is a policy choice, because the changes that are reflected in this bill mean that you're putting a cap on what hospitals could receive when they can do a lien. Well, a much smaller cap, right? Currently up to the $500 or the 1/3. So you're putting a cap on what hospitals could get through a lien you're also saying there are some instances when hospitals cannot pursue a lien at all, right? Insurance, Medicaid, Medicare. So the result of that means hospitals are receiving less. The attorney's fees, as currently written in this draft, would receive the full amount as they currently do. However, now instead of the injured person, paying, in essence, all of the attorney's fees out of their recovery, you would have the hospital paying for part of that, which is another reason why the hospitals would be receiving less through the lien process. And you have the injured party receiving more as part of the settlement process because the hospitals are receiving less. So it's a shifting in who is paying for what. And I don't know where that leaves you, because you have witnesses who all have opinions on what is the best way to break down this, because there will be circumstances where there is not enough money to cover all of an injured person's, all of the aspects of their life where they are needing to pay something either through lost wages or through medical bills or replacing a car. There's so many financial considerations as part of these circumstances and these lawsuits. And there's going to be circumstances where there is not enough money as part of the lawsuit to make that person whole. And so this would shift who is responsible for paying what.
I have a question. We previously heard, I believe it was testimony that was put into the record from a chief financial officer, I believe it was a CFO, regarding the fact that attorneys will be able to collect their fees, but the hospital will be left missing a large chunk of that. Is it within our jurisdiction or ability to also put a cap on the attorney's fees related to this?
Yes.
Oh, thank you.
I have several questions. Well, I have another question. So I
Okay.
believe we heard earlier testimony that the hospitals, and I forget who it was, would not directly bill the providers, the Medicare, the Medicaid, whatever, that go directly after. Can you explain to me as to why that is, or?
I can't explain why they make that choice, but the law allows them to pursue, the current statutory law allows them to proceed recovery through a lien, and it is silent on whether they need to first attempt to go through insurance. So why hospitals decide to proceed through one or the other, I think you've had witnesses that have touched on it a little bit, but I don't know that you've heard directly from any hospital that does this as to why they would make that choice. And just to circle back briefly to a previous question about the attorney's fees and whether in statute you could limit that recovery as you have with hospital liens, I would say yes, but also keep in mind that whenever you set a statutory limit, you also limit parties' abilities to negotiate something different, which in some cases could benefit either the hospital or the injured party or the attorneys trying to recover their fees. So anytime you put, similar to putting the cap on the hospitals being able to have a lien that's more than 25%, you are also limiting, in this situation of a settlement, the ability to negotiate.
So one of the changes, and certainly correct me if I'm wrong, I do know I'm the lead sponsor on this bill, so I should know what I'm talking about, is in this bill is that it would make mandatory that the hospitals bill insurance, so they don't get to make the choice to skip that step.
It doesn't make it mandatory, but it removes a tool for the hospitals to recover their expenses. It doesn't require, it just says that hospitals cannot pursue a hospital lien, but it doesn't say you must. But one would think that if they now lose the ability to use a hospital lien to recover their fees, that they would pursue insurance or Medicaid or Medicare payments more frequently, rather than just going uncompensated for those services.
Right. Okay. Yeah.
But it doesn't require it. The law does not require them to do it, but financially, it would not
make sense
make a
for them
lot of
not
sense
to.
to not.
Okay.
I would think.
So I don't mean to keep. I'm trying to do in my mind what is fair to all parties involved here. I realize that many times we think about the victim and so on and so forth, but I'm also trying to look at hospitals. I mean, I've heard everything from hospitals overcharged, whatever else. That's not what I'm here for. To ascertain that that's not true. But if they have a valid bill and they're charging it, and I have also heard that those premiums could shift back on other people, go to the hospital and use them. So I'm just wondering as to, I don't know if Devin can answer my question as far as why don't hospitals bill insurance companies? I guess a good starting point for me.
Devin Green, Vermont Association of Hospitals and Health Systems. Oh,
I think you.
yeah, okay.
At the risk
so
of being, I could answer that question if I were allowed
Sorry,
to.
Devin has the floor.
And the reason, I apologize, but if you want, I can answer why.
And there'll be a moment for that.
Vermont Association.
Hold on just a minute.
Vermont Association of Hospitals and Health Systems. I think I think probably the reasons vary depending on the cases and the coverage that is available. And in terms of understanding of the requirements for billing. So as I mentioned in my testimony earlier, generally you try to go after other coverage before going after governmental coverage. So Medicare, Medicaid, they pay last. There's sort of an order to these things. There is subrogation that can help where government coverage will pay and go after the insurance potentially. But there may be that sort of principle being followed as well, not wanting government to have to cover this when there's other insurance available.
It just seems to me, Senator Sears, it just seems to me that you would try to cut your losses, say they pay 70%, you'd at least go for your 70% first, and then entertain the thought of going after any potential liens on. That just seems to make more sense to me.
Yeah, and I'm happy, so I have found.
What problem the bill is trying to solve? What problem is the bill trying to solve? That's, I guess, the major question.
I mean, I can certainly speak to that some. I mean, in my view, the problem this bill is trying to solve is an almost 100-year-old practice of going after victims and leaving them of accidents and leaving them potentially with no more than $500 after they've been harmed. I mean, you know, as we've heard, this bill came from a time when only about 10% of Vermonters had insurance. So it was a tool that was really necessary, but now 97% of Vermonters have insurance and they should be able to use it without being worried or having to think about like, oh, I got in a car accident and now suddenly I have this huge bill because the hospital chose not to bill my insurance. So that, I mean, that is, as I see it, it's an update to the law that is more in line with the fact that most Vermonters have health insurance and pay for health insurance that they should get to use.
Right, it's sort of like the question I'm asked every time I go to the hospital. Is this related to military service, black lung disease, and workers' comp? Right? That's the question I get when I go to a hospital or a doctor's office. So that's the automatic question. So that's why they're asking that question. So is there somebody else we can bill?
So just to clarify, so the purpose of the bill is to get hospitals to bill any insurance providers that may be available first. Is that what you're saying?
Yes, the purpose of the bill is to eliminate the lien process being the first choice that can be made. And I know we heard from Attorney Ross that in some of these instances where the insurer has paid but liability is due, that once that judgment comes in, it can sort of back pay that.
All right. Mr. Levy, you had a point you wanted to make?
Yes, I think it's important to follow the money. And why would a hospital choose not to submit a bill, say to Blue Cross Blue Shield, as opposed to filing a lien? Because that $50,000 hospital bill, if billed to Blue Cross Blue Shield, probably is going to be paid at $30,000. So right there, you have a substantial discount. So obviously the hospital is choosing to obtain the maximum recovery. But Blue Cross Blue Shield, in that instance, will have subrogation rights. And when there is a settlement, will claw back as much of that $30,000
Okay.
as was paid. But
Yeah,
that's
thank
the
you very
reason.
much. Thank you. I get it. I suffer from that too. I don't have dental insurance, so I pay the full bill for the
Right.
dental. But if I went in there with dental insurance, I'd pay less because dental insurance pays the dentist less. I don't, I have insurance for my dog. So I suppose my insurance company pays less for the dog than I was self-paying. That's true for home health care that I get from my wife. I'm paying full boat because I have insurance, long-term care insurance, that somebody else is not paying, and I'm making up for that. So that's, I guess, I don't know which side I'm on here, but that's what's happening to me. So the dentist is probably the best example for me. If the insurance company would pay $300 for what's billed to me for $500, I'm paying $200 more and making up for the lack of the insurance company.
Absolutely.
Senator Bohosky, you have a question?
Yes.
I think my question.
Or maybe a
might be-
comment. I'd be happy to hear that too. Yeah.
I think my question might be for Sarah to just clarify the point that was made. So the reason that an insurer might pay less is because they've negotiated a rate that provider has agreed to, as opposed to just charging someone without insurance or charging in a medical lien, whatever they want. Okay, thank you. Okay.
Maybe I should start. People don't have dental insurance and negotiate with the dentist for our rate. But then there's such a lack of dentists, I don't think it would work. I had an email when being in the hospital association. Is she in the room by any chance?
Yes.
Yeah, Devin's in the room.
Oh, good. Have you and others worked out some agreement here on this bill? Or are in the process of working out some agreement?
Yeah, Devin Green from the Vermont Association of Hospitals and Health Systems. We are in the process of working something out.
So if we took this up a week from today, would you hopefully have an agreement? We're well
Yes.
beyond we're well beyond crossover date, so we're going to have to do one or two things with this bill: either pass it out and it would go to the rules committee, or tack it on to a House bill. Just so to be clear.
Senator Sears, Dave
Yes.
Mickenberg is in the room. He has a response.
Okay.
Hi, Senator. David Mickenberg on behalf of Vermont Association for Justice. Yeah, we've been talking with Devin, Sarah, and others about this, and I think there are some areas that we think we can work on. And I think by next Friday, absolutely, we should be able to at least come back and say, these are the areas of agreement. There may be some policy decisions that you need to make as a committee, but I think we can make progress on a few of these sticking points.
Well, just based on the fact that it's a 100-year-old law, maybe it is time to update it.
Perhaps.
Things have certainly changed in the hospital and the healthcare world. the last 100 years.
Next Friday at 10 o'clock?
Well, whatever we've got on the agenda, Peggy. Friday night.
10 o'clock. Next Friday.
Senator Hashim, okay with that?
Okay with that.
Senator Baruth, did you have a comment on how to get there from here?
Well, I think we're past crossover, so there's still a path with House leadership theoretically.
Okay.
But we'll have to investigate that. We're compiling a very short list of bills that have missed that we're interested in getting dispensation for, but we have to give them one for every one we get, so.
Yeah, well, there may be a bill in somewhere. I know that Senator Lyons would be interested in looking at whatever we do here, so may take.
I don't know if there's a miscellaneous that'll come back to us.
Yeah.
What we could put it on.
Miscellaneous judiciary bill.
Yeah.
But I do know Senator Lyons will want to look at the bills.
In closing, Senator Sears, I like this approach that you suggested. I don't feel that, it should be our decision here to invoke what's right and wrong. And if the parties can sit down and agree upon something and bring it back to us, where we can address maybe some policy issues, that's great. So I appreciate the bill moving in that direction.
Thank you. I do too. Always hopeful when the parties can get together. Well, we've done it once again. We've been so efficient with our time that we're got an extra break between now and the time that we have to be on the floor. I want to, if we could, I just want to give you a healthcare update